Okay, the court is in session, back in session. In clause numbers 2-4, CCCR 1212, and clause number 2-4, CCCR 1366. Both cases are style the state of Texas versus, is that Deontay Sostan? Mr. Sostan, would you please raise your right hand? Mr. Sostan, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Sostan, you may put your hand down. How are you doing, Mr. Sostan? You doing good? That's good. Now, Mr. Sostan, you're represented in your cases by your attorney, Marcus Wilkerson. Mr. Wilkerson, how are you doing?
Good morning, Your Honor. I'm doing fine.
And
Thank
Mr. Wilkerson, do you waive a record in Mr. Sostan cases?
We do, Your Honor.
Mr. Sostan, I have before me a document on my computer. This document is titled Information, and this document is in clause number 2-4 CCCR 1212. In this document, it alleges that you, Deontay Sostan, on or about May 7th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of interference with public duties. And Mr. Sostan, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
Yes.
Now, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty? Mr. Sostan, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? Now, on the first page, there's one box that's checked, states that this is a Class B misdemeanor. Range of punishment for a Class B misdemeanor is confinement in the Jefferson County Jail for up to 180 days, a fine that does not exceed $2,000, or you could be given both such fine and confinement. Do you understand the range of punishment for this offense?
Yes, sir.
Now, on page 2 of this same document, there's a signature DS on the line next to a box. Well, the initials on a line next to a box that says guilty. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature? And on the next document that's titled trial court certification of the defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box check states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement? I also have before me a document that is titled Discovery Certification. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
At the top, now, before you sign and initial these documents that I just showed you, did your attorney go over these documents with you?
Sir.
And did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge? Mr. Sostan, are you a citizen of the United States? State?
Silver 6-1.
Any
No
objection?
objection.
No objection. State's Exhibit Number 1 will be admitted. And Mr. Wilkerson, you've advised in counsel, Mr. Sostan, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Sostan, your attorney, Mr. Wilkerson, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Mr. Sostan, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement in these cases is 50 days time served, protocol sex, and retired joint concurrent.
Okay, Mr. Sostan, the state is offering that you serve 30 days?
50, Your Honor.
50. Okay, yeah, that you serve 50 days in the Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail because you've already served 50 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. That just simply means that you will not be required to pay the court cost because the time that you have spent in jail has already paid off the court cost. Therefore, the court costs will be taxed and retired. And this case will run concurrent with cause number 24 CCCR 1366. Mr. Sostan, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, sir.
Mr. Sostan, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Sostan, I'll move to your next case. Your next case is cause number 24 CCCR 1366. And I have before me on my computer a document that is titled information. And in this information, Mr. Sostan, it alleges that you, Deontay Sostan, on or about April 26th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest. Mr. Sostan, do you understand what you've been charged with?
Yes, sir.
And to this charge, how you plead? Guilty, not guilty, no contest.
Guilty.
Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Sostan, I also have before me a document that is titled misdemeanor plea admonishments. Do you recognize this document?
Yes, sir.
And on page 2 of the same document, there's set of initial DS on the line next to about this check guilty. Did you place your initials on this document?
Yes, sir.
On page 3 of this document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next page, or in the next document rather, that's titled trial court certification to defendant's right of appeal. Do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to appeal. Do you understand that statement? And as earlier, I presented a document to you that is titled discovery certification. It had this cause number and the previous cause number on there, and it has your signature on that document. Do you remember that? Now, before you sign and initial all the documents that I've just mentioned, did your attorney go over these documents with you? And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State,
Devil states one.
any objection? No objection, states exhibit number 1 will be admitted. And Mr. Wilkerson, you've advised and counseled Mr. Sostan, is there any evidence that he's currently mentally incompetent to stand trial?
Not in this case either, Your Honor.
And Mr. Sostan, your attorney, Mr. Wilkerson, has advised and counseled you in this case. Are you satisfied with his services in this case?
Yes, sir.
Has he provided fully effective and competent legal representation? Sostan, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
Yes, Your Honor.
And what is the agreement?
As with the previous case, the agreement in this case is 50 days time served, protocol sex, and retired joint concurrent.
Mr. Sostan, the state is offering that you serve 50 days in Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail because you've already served 50 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. And the state will be running this case concurrently with the previous case, cause number 24 CCCR 1212. So stand, do you understand the state's offer?
Yes.
You think the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer? So stand, I follow the plea bargaining agreement that you have entered into with the state. Now, Mr. So stand, you're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day. Next case is Fantasia Jemiah Williams. I don't, that one is not ready? Oh, just tell her, have a seat. I thought it was ready, it's not ready. I see a McElroy, I see a Shores. Or, who is your attorney? Okay, we'll wait for him to come back in. Just have a seat.
I also have one other case, Your Honor, on the docket. I do not believe he has showed up today. My office did speak with him on Friday, if the court recalls. These were originally Wednesday morning sittings that were moved because I won't be available Wednesday morning.
Oh, right.
So, but he has been, like I said, they communicated with him on Friday this morning that he has not answered his phones.
Raul Jimenez. This is cause number 23 CCCR 0768, case of style State of Texas versus Raul Jimenez. Raul Jimenez was scheduled to be in court this morning at 9 a.m. At about 9 a.m., of course, barely called the name of Raul Jimenez at the courthouse door. Raul Jimenez did not answer. Raul Jimenez has not appeared in court since the court has been in session. The time now is 11:09 a.m. on today's date. Ms. Bailiff, would you please call the name of Raul Jimenez at the courthouse door?
Yes, sir.
Okay, Raul Jimenez's name was just called at the courthouse door. Raul Jimenez did not answer. A reasonable time has passed to give Mr. Jimenez an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
They move Sir bond forfeiture.
That motion will be granted. Raul Jimenez bond forfeited and a warrant shall be issued for his arrest. And, Mr. Wilkerson?
Wait for Ms. Williams and then.
Okay.
That approach on Summerall.
Summerall.
That's the trial. It's-
Okay, what-
Going back to-
Summerall.
Stays ready as well, Your Honor.
Oh, it's on the trial doc. Where's Summerall?
Summerall.
Caleb Blake Summerall? That was supposed to be, that was a JP reduction, that was
He
rejected.
refuses. sir.
Okay.
Right.
Mr. Summerall, you need to come back this afternoon, 1:30, for your jury trial, Yeah.
Be here at 1:30.
1:30.
I think that's all I have here.
Okay, we'll see you at 1:30. Mr. Summerall, that door is locked, you need to go through the other door. Is that Miss, on my door, there's a, on my desk, there's a green law book,
Okay.
and they have some paperwork in it. I need that
Just the paperwork?
document and the paperwork
Okay.
brought to me. We're going to, call Mr. Johns, what's your client? Where, is he on the docket? I put him on the docket. His motion, a motion was set today. Let me see. Said that I had a motion here and set today.
Mr. Garrison is sir.
Okay, hold on a minute. Yeah, that's it. It's a mouse, but it wasn't. What docket is he on? Okay, I don't see one.
Sorry, I'm gonna need the spelling.
That was a writ. You got that, Rick?
I just don't know if we have a case.
No, there's no, that's right, no
Yeah.
case was filed, was it? Was the case
And
filed?
here's the bottom line.
Yeah, hold on a minute, let me get my, yeah, that was it, no case was filed. You filed a writ of habeas corpus.
Correct.
Okay, hold on a minute, and
Oh.
it gave him they gave it a number.
Here's the number they gave me.
Yeah, I know. I mean, she's
Yes.
getting my paperwork. Hold on a minute. Okay, this is cause number 24 CCCR 0348. Case of style the state of Texas versus Vantasia Jemiah Williams. Ms. Williams, is that your full name?
Yes.
Ms. Williams, would you please raise your right hand? Ms. Williams, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Williams, you may put your hand down. How are you doing, Ms. Williams? That's good. Now, Ms. Williams, you are representing your case by your attorney, Attorney Marcus Wilkerson. Attorney Wilkerson, how are you doing?
I'm well, Judge.
That's good. And Mr. Wilkerson, do you waive a record in Ms. Williams' case?
We do, Your Honor.
Ms. Williams, I have before me a document that is titled misdemeanor. Well, the document is titled information. This document was filed by the Jefferson County District Attorney's Office. And in this document, it alleges that you, Fantasia Jemiah Williams, on or about December 25th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of fleeing police officer. Ms. Williams, do you understand what you've been charged with? And to this charge, how do you plead? Guilty, not guilty, no contest? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yes, sir.
Ms. Williams, I also have a document on my tablet that's titled misdemeanor plea admonishment. It's also labeled as State's Exhibit number 1. You recognize this document?
Yes.
And on page 2 of this same document, you got initials, but you forgot to check the box. Yes, yeah, set of initials, VW on the line next to a box that's checked guilty. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled trial court certification, the defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box check states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Where's her?
Right here, Your Honor.
Okay. I also have a document that is titled discovery certification. She put on initials, what, at the state and the, she signed on your line and her line.
Because he has on this.
It's just gonna white it out. She can, you got some white
I
out?
don't have white out. either.
Oh,
I'll just resign and I'll fill it out.
I don't know if this thing will work.
It'll be.
oh,
quick,
here you
Judge.
go.
He left.
He's- CCCR 0348. You know,
Okay, now, Miss,
did I?
You need to
I'm
sign.
sorry. I handed
Yeah.
it back to you. It's a Monday.
okay, now, Miss, you have the audit? Is it attached? Okay. Also, I have before me a document that is titled discovery certification. You recognize this document? Do you?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And now, before you sign and initial these documents that I just showed you, did your attorney, Mr. Wilkerson, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, I do.
And is everything in these documents true and correct, to the best of your knowledge? State,
State offer states one.
any objection?
No objection.
No objection, states exhibit number 1 will be admitted. Mr. Wilkerson, you advising counsel, Ms. Williams, is there any evidence that she's currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Williams, your attorney, Mr. Wilkerson, is advising counsel you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Williams, I will accept your plea. They didn't even check the box off. Let me see. Okay, you probably gotta check the box where it says guilty.
We just did that. Oh.
Oh, here it wasn't signed. And is that a 2 or a 6?
It's a 6, Your Honor.
Six.
That first, oh, okay.
Yep.
Now, Miss, Vantasia, I will accept your plea guilty. I will find that you are mentally competent to stand trial. I will also find that you're playing waivers with freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 6 days in the Jefferson County Jail, credit for 6 days into tax and retire all court costs.
Okay, Ms. Williams, state is offering that you serve 6 days in Jefferson County Jail. You would not have to serve any more time in the Jefferson County Jail because you've already served 6 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not have to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Ms. Williams, do you understand the state's offer?
Yes, sir.
You think it's state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Ms. Williams, I'll follow the plea bargain agreement that you've entered into with the state. Stand in front of the court coordinator. Follow the directions of the bailiff. Once you're finished following the directions of the bailiff, you're free to go and you have a blessed day. Okay, now they're gonna do the writ of habeas corpus.
Thank you, Your Honor.
Okay, you're free to go and you have a blessed day and Merry Christmas to you too.
Yes, Judge.
Cause number 24 CCCR 2654. Case of style of state of Texas versus Landon Gillette,
Hi,
Paye.
hi,
Okay,
his grandfather was Brandon's photographer.
Mr. Paye, your full name is Landon Paye.
Yes, sir.
How you doing, Mr. Paye? I'm doing fine, thanks for asking. Mr. Paye, you represented the case by your attorney. Attorney, Attorney Theodore Johns Jr.
Yes, sir.
And Mr. Johns, how you doing?
Pretty good, sir.
That's good. Now, Mr. Johns, I have before me a writ of habeas corpus that was filed in cause number 24 CCCR 2654 by you, Mr. Johns. Would you like to go forward on your motion?
Yes, sir. We filed this case on about October 31st, 2024. There was no case number for this case. The case number was created and Becky Bertrand served the district attorney's office at that time. Of that, we had filed this application. At the time of filing this application, we relied on Article 32.01, defendant in custody and no indicted presented. In that situation, the Code of Criminal Procedure says as follows: when the defendant has been detained in custody or held to bail for the defendant's appearance to answer any criminal accusation, the prosecution, unless otherwise ordered by the court for good cause shown, supported by affidavit, shall be dismissed. It's a shall be case. And the bail discharged if the indictment information not presented against the defendant on or before the last day of the next term of court, which is held after the defendant's commitment or admission to bail, on or before the 180th day, the date of commitment or admission to bail. When we filed this case, was there an attachment, which showed that at that time, it was about 270 days had passed before there had been anything done in the case. Okay, as of last night when I checked the e-file system, the prosecution had not met the statute by filing a supporting affidavit or an answer to this particular case. Okay, so I don't know what the judge is thinking, but I know what I'm thinking. I'm thinking that the statute should be followed. It's been more than 180 days past. I'm thinking that we filed an attachment that showed that when he was committed to the jail system. And I'm thinking that because the prosecution had not filed a sworn affidavit, that's another chip in the stone. There's no, I've heard someone mention here on sidebar that it's been filed, and on sidebar prior to court report again here, there was an indication that it may be moot. The statute doesn't say that. The statute shall say, the shall be statute that says shall be dismissed if it's not filed 180 days. It doesn't say maybe, if, and, or but. That's what I'm thinking. And I'm also thinking that the prosecution has not met the burden by filing a supporting affidavit.
Okay, state.
Your Honor, this offense date was committed on February 4th, 2024. This case was filed October 30th, 2024. I'd like to address there was no sidebar whatsoever that we spoke of this as moot. Mainly, we received this writ of habeas corpus at a time where it was not filed, where we didn't even have a cause number until probably a week after it was. So this just got brought to our attention. I would argue that we haven't met our verdict because we haven't had the chance to try the case yet, Your Honor.
Your Honor?
Yeah.
What's the excuse for no sworn affidavit?
The case was just filed on October 31st, Your Honor. If he wants discovery, we can get him discovery. But in terms of the affidavit,
You're running around the statute. Judge,
No. Go ahead.
the statute says 180 days. There's no excuse. 180 days. Says sworn, supported by affidavit. No excuse. Okay, you can't say, oh, they're not even a flimsy excuse. Oh, we just filed it. Okay. No excuse. And then I don't know if you know the technical terminology, Judge, or what I'm about to say, but we did change computer systems up here to an Odyssey system. And basically, that's what they call blockchain technology. I don't know if you're familiar with that term. You probably heard the term crypto. Okay. Blockchain technology means you can't change computer records. Okay. They got this letter by the district attorney on October 34th. I was never served. They say it's a new case file. I was never served with that. You can look at your records and see that I was never served with that. But yet still, the prosecution knew that this writ of habeas corpus. If they have filed a sworn affidavit and checked service of process on that computer system, the Odyssey system, it would show in your machine that I was served with it, but I wasn't. So what we have here is a situation where they got served with this 180 days, passed by. They didn't answer this. Okay. Now they want to give the excuse, well, we filed it, so it should be mute. Statute doesn't say that. Okay. That's the second period that we've been building this foundation on. The third period was they can't prove that they served me. You can look on your machine because Odyssey is a blockchain technology. If they check that box, Attorney Theodore Jones was served, it was shown on your machine. It's done. Because I wasn't served. Had no knowledge of this at all. It says, I'm looking here. It says nothing's ever been filed in this case. My writ of habeas corpus doesn't mean it. They have filed a sworn affidavit. The statute calls for that.
Okay.
I urge that you dismiss the case. I don't know what
Okay.
you're thinking about, but I know what
State-
I'm thinking.
Your Honor, we couldn't have filed a sworn affidavit in this case for the defendant because we didn't have any information until recently. Looking at everything on the computer, the case was not even received by our office until recently. And if we were aware of his existence as it was received, we would have provided that. We didn't get any notice of this until we actually saw the writ before the case was even filed.
That's the whole point, Your Honor.
And Glenda even had to create a system, I believe, put it on the docket.
That's the whole point.
Oh, okay.
It's past 180 days. They're getting all kinds of excuses, but it's past 180
Okay.
days. Can't get around it.
Not an excuse, Judge, we just did not receive it.
So you're saying y'all didn't receive notice
We-
of the writ of
We didn't
habeas corpus?
we didn't receive the writs until 11/5. We didn't receive an actual filing. The case wasn't filed in our office until October 31st.
Okay, well, we're talking about two different things.
Right.
Okay. When did you receive the writ?
October
That's
31st.
that's what we're here.
October 31st, Your Honor.
So you knew about the writ on October 31st.
I received it 11/5 because it wasn't even in the system in Odyssey at that point. We
So you
received it by
received-
email.
So you received the writ November 5th,
By the looks of it, yes, Judge.
all right,
Your Honor,
by email.
That's
Yeah.
correct. We were never e-filed in this case
Yeah.
whatsoever.
Okay,
Becky Bertrand walked this letter down to their office and hand delivered it to them.
okay.
This wasn't faxed, it wasn't email, she hand delivered it to them because she was aware of the problem with the system.
Okay. Anything else to say?
So there's
Anything
nothing
else in the
further.
defense? That,
Your Honor,
anything else?
on 10/31st, Roxanne Crossberg and Becky, our attorney, delivered this to
Okay.
the district attorney. At that time, it was 27
It's
days late.
on the 14th,
Okay.
on the 14th from this one.
Where? No, that's last month.
And it still
Yeah,
doesn't,
14th of last.
don't have a sworn affidavit in the file.
I
Okay.
misspoke, Your Honor. It was filed within the court on 11/14. We received this by email 11/5. It wasn't hand walked.
She hand walked it.
Okay, well, okay. But at some point, they were given notices, whether
That's
it was
correct.
hand walked or whether it was received by email.
That's correct, Your Honor.
Okay, so at this time, you have anything else? You have anything else? You have anything else?
Another than repeat what I said, they were, Ms. Bartran hand walked it to the district attorney. And
Okay.
even it was emailed to him, and put in that file, which I guarantee they can't produce an email on this day.
Okay,
And then the next thing over, it, they still haven't produced a sworn affidavit as per the statute.
okay. Okay, so,
I urge that this case be
at
dismissed.
this time, the court is gonna take this, matter under advisement, gonna do some research on those issues. All right. Okay, we're in recess.
Thank
on
you,
this
Your Honor.
case. You are.
And recess means, you're gonna research that?
Yeah, we gotta
today,
research the issue, yeah.
Or you're gonna research that?
We're gonna get a copy of your transcript. We'll go through the transcript.
Yes, sir.
We're gonna, apply the law to the facts.
Is that
And then we
today?
got, no, it's not today.
Okay, yes,
It's gonna, then we're gonna make a ruling. on it.
because I was wondering how you could do, I'm trying to do that to say.
No. We're gonna have, our court, reporter,
Yes, sir.
you do a transcript for us. And then once we get that,
Yes, sir.
and then we're gonna, research it,
Yes, sir.
and then we'll make a ruling.
Yes, sir.
All right. Y'all free to go?
Thank you.
All right, you have a blessed day. Where did Mr. I'm looking for Mr. Crenshaw. He's working on somebody else?
Probably. I do have
Okay.
a plea with, Mr. Grove.
Mr.
I don't know
Grove?
if it's
Okay,
ready.
let's do Mr. Grove. That's Zarak Scott, is that correct?
That's not a plea, Judge, but that's an announcement.
Okay, well, Zarak Scott, let's do that one first.
Yes, sir.
Mr. Scott? Okay, how you doing, Mr. Scott? I'm doing fine, thanks, Mr. Scott. You're represented in your case by your cases by your attorney, David Grove. Attorney Grove, how are you doing?
Good, Judge, thank you.
That's good. Now, Mr. Grove, what's your announcements?
Judge, I think that we will be able to dispose of these cases, but Mr. Scott has a felony, motion to revoke probation that these are the basis of. And until that case is disposed
When,
of,
do you have a court date on the felony?
no, sir, I don't. I tried to call the probation officer, but she's out of town apparently.
But the motion to revoke probation on the felony case has been filed. Is that correct?
Yes, sir.
Okay, so they should have a court date. But just, what we're going to do, we're going to reset these cases with the felony case.
Yes, sir.
The court coordinator is going to look in the computer and give you a date that the felony case is gonna set on, and we're gonna set it on the same date, okay?
I'll be sent on the same day that Stevens. Okay, so we do it all on the same day.
Okay, this is Zarak Scott on page 3 and 4 of the announcement docket. No, I don't think he went to court today. Okay, y'all can stand in, you can stand in front of the court coordinator, she give you reset. Once she give you a reset, you're free to go, and you have a blessed day. Yes. Yeah, that's it. Yeah, all right, thank you. Let me see, cool.
Judge, you also have two.
Yes, I see you got Howyer and
trial,
Stan.
like, one will be a plea. And
Let's do the one that's, the first one.
The plea.
No, Daisy Sam?
they-
So he has a motion on file in that case.
They're gonna, okay. Miss Sam, your full name is Daisy M. Sam?
Yes, sir.
How you doing, Miss Sam?
I'm doing-
That's good, Miss Sam. You're represented in your case by your attorney, Attorney David Grove, Attorney Grove. What,
No.
and, state, you said you had a motion in this case?
That's correct, Your Honor.
Okay, so it's a motion for continuance.
That's correct, Your Honor.
You, Mr. Grove, you have any objections?
No, Your Honor, it's not availability of a witness, and I don't oppose those.
Okay, this motion is gonna be granted. We're gonna reset Ms. Sam. Give him a reset. We're gonna need a reset date on Ms. Sam. She's on the jury trial docket, page 3. She is? What's the other
No,
docket?
She has other cases, Your Honor, from a different incident, so you wanted this.
What?
You wanted this case specifically set on the trial docket, this type of case.
Okay, well, we'll just keep them together.
Yes, sir, there are cases, actually, on page 5. Pre-trial docket,
Okay.
and she has cases on
Right.
page. Looks like on page 5 also of the.
Yeah, put them all on the trial docket. Okay. We're gonna reset them, give us a reset date. Okay, these cases be reset February 10th, 2025. Ms. Sam, you're gonna get your reset from our coordinator. Once you get your reset, you're free to go and you have a blessed day.
Yes, sir.
All right. Larry Hawyer,
That's a plea, Your Honor, yes, sir.
is it Haller? Okay, this is cause number M333-834, case of style of state of Texas versus Larry Haller. Ms. Haller, is that your full name?
Yes, sir.
How you doing, Mr. Haller?
Better.
That's good. Mr. Haller, you're represented in your case by your attorney, Attorney David Grove. Attorney Grove, do you waive a record
Yes,
in
Your
Mr.
Honor.
Haller's case?
Yes, sir.
Mr. Haller, I have before me a document that is titled information of this document is on a computer. In this information, it alleges that you, Larry Haller, on or about November 12th of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault family violence. Mr. Haller, you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Haller, how you plead guilty, not guilty, or no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily,
Yes.
and are you pleading guilty because you are guilty?
Yes, sir.
Mr. Haller, I also have before me a document that is titled misdemeanor plea admonishments. Document is also labeled State's Exhibit Number 1. You recognize this document?
Yes, sir.
And on page 2 of the same document, there's a set of initials LMH on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, I did.
And on the next document, there's titled trial court certification of the defendant's right of appeal. Well, actually on the same docket, is this your signature above the line that's titled defendant page 3?
Yes.
And on the next document, that's titled trial court certification of the defendant's right of appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes, sir.
defendant? Mr. Haller, before you sign and initial these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that he went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Haller, are you a citizen of the United States?
State offer states one.
Any objections?
No objection.
No objection states exhibit number 1 will be admitted. Mr. Grove, you've advised in counsel, Mr. Hall, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Hall, your attorney, Mr. Grove has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Hall, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find guilty beyond a reasonable. State, do we have a plea bargaining agreement?
We do, Your Honor.
What is the agreement?
In exchange for defendant's plea, the state's offering 9 days in the Jefferson County Jail, credit for 9 days, and to tax and retire all court costs.
Mr. Hall, the state is offering that you serve 9 days in Jefferson County Jail. You'll be given credit for the 9 days that you already served. And the court costs in this case will be taxed and retired, which means that you would not have to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Hall, do you understand the state's offer?
Yes, sir.
You think the state's offer in your case is fair and just?
Yes.
You accept the state's offer?
Yes.
Mr. Haller, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Haller, before you stand in front of our court coordinator and follow the directions of the bailiff, they give you some a model written admonition on the ineligibility to possess a firearm and ammunition. And it states in accordance with the Texas Administrative Code, section 176.1, the court hereby admonishes you of the following. Number 1, you are by entry or order or judgment ineligible under Texas law to possess a firearm or ammunition. Number 2, beginning now, if you possess a firearm or ammunition, could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number 3, under Texas Penal Code section 46.013, a firearm means any device made, designed, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device related to their use. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is 1, an antique or curio firearm manufactured before 1899, or B, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information about, for more information about how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, Unlawful carrying weapons. Penal Code Section 46.04, Unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse and neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.06, warning on protective orders. Now, Mr. Haller, the written admonition that has been given to you is for your records. You're gonna stand in front of the court coordinator, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go, and you have a blessed day.
Thank you.
Okay.
No. Okay.
Clark Alexander Shores.
We're ready, that's okay, Judge.
Okay.
And Judge, if you don't mind, could we call, most of my cases today are pleas, except for I think 2.
You want me to do the
Could we
please
let
first?
go that,
Okay, let's do that. Hold on, yeah, Mr. Shores, just have a seat. We're gonna call,
Can we start with Trevor Elliott, Judge?
no, that's not a plea. Hold on. Trevor Elliott.
He wasn't even supposed to be on the docket today, Judge. I was supposed to have gotten him reset. It's a brand new case. And it was kind of slipped through. If we could just reset him for another announcement in maybe March, I'll work on
Elliott,
getting him resolved.
Elliott,
Trevor Elliott, Judge. I think it might be on your announcement docket. I don't think it's on the pretrial docket.
it is? I see his name. I see, it it is. It's on the, it's on the announcement document.
Yeah. I should have
Page
gotten this one
2,
reset, Judge.
Trevor Wayne Elliott.
Yes, sir.
How you doing, Mr. Elliott?
Good about yourself.
I'm doing fine, thanks for asking. Mr. Elliott, you're representing your case by your attorney, Attorney Corey Crenshaw. Attorney Crenshaw, how are you doing?
I'm doing well, Judge.
And Mr. Crenshaw, what's your announcement in Mr. Elliott's case?
Judge, this is a brand new case. If we could just reset to March, I'll be working on the resolution. It'll likely be a pretrial diversion. I just don't know if I'll have him submitted on the February docket. Because I'm not sure.
We can put him in because, I think it's every other month.
The next one's in February, Judge.
Yeah, it'd be February, yeah. So what we normally do is reset it a week after that. If he's not on, you get it reset. Then we're
Okay.
gonna reset it after that.
Sounds good, Judge. That'll work.
Okay, what's that date? 17th, okay. Mr. Elliott, you're gonna get your reset from our coordinator. Once you get your reset, you're free to go and you have a blessed day.
You too.
Okay, who's your other client that's being reset? Who's your other client? This is it Breeden? Who?
Maggio. He has 2 cases.
Okay,
Judge.
Maggio. Jason Michael Maggio. Mr. Maggio, is that your full name?
Yes, sir.
How you doing, Mr. Maggio?
Pretty good, Your Honor.
That's good. Now, Mr. Maggio, you're represented by your attorney, Attorney Corey Crenshaw. Did we get any bond conditions on here? Mr. Crenshaw, what is your announcement in Mr. Maggio's cases?
Your Honor, this is a plea. The state has to convey the offer and the resolution to the victim, and this will be a dismissal on the assault family violence case and
Okay,
a
give me
plea on
those,
the criminal trespass.
bond conditions. Yeah, he'll be under bond conditions till it's resolved.
Bond conditions for what, Judge?
Until his case is resolved, he's on bond. Let me see, give me that. These bond conditions.
Okay, Judge,
Commissioner?
if the court will just give me a copy, I'll go over them with them.
Well,
after
yeah,
court.
I usually just, let me do this here. Now, da, 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 da. Okay, now, Mr. Collier,
No,
excuse me, Mr. Maggio. Right,
yes,
okay, you have 2 cases. You're gonna be given some bond conditions. And basically, the first condition is that you cannot have committed a crime against this state, any other state, or against the United States. You understand that condition?
Yes, sir.
And condition number 2, the court shall, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest any defendant who, 1, refuses to submit to a test for drugs and alcohol, or 2, submit to a test for drugs and alcohol when directed to do so by the court. And there's presence of drugs and alcohol in your body. Do you understand that condition?
Yes, Your Honor.
Now, condition number 3, you shall not communicate either directly or indirectly with the alleged victim of the pending offense, and shall not go near any residence, other school, and other location of the alleged victim. Do you understand that condition?
Yes, Your Honor.
Now, condition number 4 doesn't apply. Condition number 5 does apply. States that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code Act and engage in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that?
Yes, Your Honor.
Okay, so your attorney is we're gonna get these bond conditions to your attorney, and your attorney is going to make sure that you get these bond conditions, okay?
Yes, sir.
You're gonna get your reset. Well, you're gonna get a reset to his attorney.
Yes, I can.
You wanna keep it on this, I see, you wanna keep it on that same day, that February date?
the February 17th.
Yeah. Okay, so these cases are gonna be reset to February 17, 2025. You're gonna get your reset from our court coordinator. Once you get your reset, you're free to go, and you have a blessed day.
Yes, sir. Thank you, Your Honor.
You're welcome. Thank you. So what is? What warrant? You talking about the guy in the back? Oh,
If you could call Breeden, Judge John Breeden.
Breeden, Mr. Breeden? Here you go. These are the violations that you make. So,
Judge, this is a hunting violation case. No, sorry. That was a
read.
joke.
Oh,
This is, close. It's a voting.
yeah,
violation.
voted, yeah. Yeah.
And,
I see he looked at you.
we are very close to a resolution.
Oh,
but
okay.
She needs to verify one thing.
It's a
for us,
reset?
Judge. Yes, so if we could please come back on that February 17th.
Okay, this case be reset February 17th,
Yes, sure.
2025. You're gonna get your reset. Once you get your reset from our coordinator, you're free to go and you have a blessed day. Okay,
All right. Now
Are
we're
you
ready
ready?
for Mr. George, Judge.
yeah, Clark Alexander Shores,
We abandoned the enhancement in this one, Judge.
you abandoned enhancement, okay. Okay, this is on, hold on a minute, hey. Shores. On the pre-trial conference document. Shores. Clark Alexander. Pre-trial?
It's on the pre-trial conference docket.
Yeah. I'll pass it. I'm looking for, I guess I was, there it is, I'm looking for Clark. Okay. This is cause number 23 CCCR 0783, case style of state of Texas versus Clark Alexander Shores. Mr. Shores, is that your full name?
Yes, sir.
How you doing, Mr. Shores?
Good, sir.
That's good, Mr. Shores. Would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Do.
Mr. Shores, you may put your hand down. Mr. Shores, you're represented in your case by your attorney, Attorney Corey Crenshaw. Mr. Crenshaw, do you waive a record in Mr. Shores' case?
We do, Your Honor.
Now, Mr. Shores, I have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you committed the Class A misdemeanor offense to drive while intoxicated. Second, however, the state is abandoning the enhancement paragraph in this information. And so instead of being charged with a Class A misdemeanor, you'll be charged with a Class B misdemeanor.
Yes, sir.
DWI. Now, this information alleges that on or about September 25th of 2022, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Shores, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Shores, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily,
Yes, sir.
and are you pleading guilty because you are guilty?
Yes, sir.
Mr. Shores, I also have before me a document that is titled Misdemeanor Plea Admonishment, also labeled as State's Exhibit 1. You recognize this document?
I do.
On page 2 of the same document, there's a set of initials on a line next to the box that said guilty. Did you place your initials on this document?
Yes, sir.
And on the third page, there's a signature on the bottom. At the top of the space, that's above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, it's titled charcoal certification, the defendant's right of appeal. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement?
I do.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to appeal. You understand that statement?
Yes, sir.
I also have a document on paper that's titled discovery certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Shores, before you sign and initial these documents, did your attorney go over these documents with you?
He did.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct
It is.
to the best of your knowledge? Mr. Shores, are you a citizen of the United States?
Yes, sir.
State of the state's one.
Any objections?
No, Your Honor.
No objections. State's exhibit number 1 will be admitted. And Mr. Crenshaw, you've advised and counseled Mr. Shores. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Shores, your attorney, Mr. Crenshaw has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
He has, Your Honor.
Mr. Shores, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, Do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 18 months deferred probation, $2,000 fine, 24 hours community service, and the state has agreed to a 12-month interlock term.
Yeah, I was commissioners.
24, Your Honor.
Okay, I was looking at the right, okay, 24. You know what? What is the court called? What's the court? 392? Okay, Mr. Shores, the state is offering that you serve 18 months deferred adjudicated probation during the 18-month probationary period. You'll be required to pay a fine of $2,000 plus court costs of $392. You'll also be required to pay a DWI conviction fine of $100. You'll be required to pay probation fee of $6,000 a month, or you'll announce fee of $15 a month, and a reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 when the day the police shuttle for the evaluation be needed. You'll be required to pay an additional $50. Now, your total amount in installments, that is the total amount that you will be required to pay each month while you're on probation is $227 a month. Will you be able to pay the $227 each month?
Yes, sir.
You'll also be required to perform 24 hours of community service. You'll install the interlock device on any vehicle that you own or operate for a 12-month period. Let's see, you also attend and complete the DWI education class, have an alcohol assessment, and adhere to the other standard conditions of this probation. Mr. Shores, do you understand the state's offer?
Yes, sir.
You think that the state's offer in your case is fair and just?
I do.
Do you accept the state's offer?
Yes, sir.
Mr. Shores, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Shores, if you successfully complete this probationary period, this case will be dismissed. It will not appear in the record as a conviction. And you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Now, Mr. Shores, you're gonna stand next to the court bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Yes, sir. Thank you, Your Honor.
Next case is Robert Douglas Marabella. Mr. Marabella, your full name is Robert Douglas Marabella.
Yes.
Mr. Marabella, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Marabella, you may put your hand down. How are you doing, Mr. Marabella?
Doing well today, Judge. How about you?
I'm doing fine, thanks for asking. Mr. Marabella, you are represented in your case by your attorney, Attorney Kurt Crenshaw. Attorney Crenshaw. He has two cases. Mr. Crenshaw, do you waive a record
We do, Your
in
Honor,
Mr. Marabella's cases?
in both of his cases. Yes, Your Honor.
Okay. Mr. Marabella, in cause number 23 CCCR 2290, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Marabella, it alleges that you, Robert Marabella, on or about September 14th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offensive harassment. Mr. Marabella, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Marabella, how do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
I am, yes, sir.
Mr. Marabella, I also have before me on tablet a document that is titled Misdemeanor Plea Admonistration. Do you recognize this document?
Yes, sir.
On page 2 of this same document, which is labeled States Exhibit 1, you recognize, are these your initials, RM on the line is text
Yes.
guilty. On the next page, above the line that's titled Defendant, is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document. And is this your signature on the line that's
Yes,
titled
sir.
Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement?
Yes, sir.
I also have another document that is titled Discovery Certification. You recognize this document?
I do, yes, sir.
And is this your signature on the line that's titled
It
Defendant?
is, yes, sir.
Mr. Marabella, before you sign and initial these documents that I just showed you, did your attorney go over these documents with you?
He did, yes.
And did you understand everything that he went over?
I do, yes.
And is everything in these documents true and correct
It is,
to the best of your knowledge?
it is, yes.
Mr. Marabella, are you a citizen of the United States?
I am, yes, sir.
State,
Stay up for states one.
any objections?
No, Your Honor.
No objection, states exhibit number 1 will be admitted. Mr. Crenshaw, you have advised and counseled Mr. Marabella. Is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Marabella, your attorney, Mr. Crenshaw, has advised and counseled you. Are you satisfied with his representation?
Absolutely.
Has he provided full, effective, and competent legal representation?
He has.
Mr. Marabella, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
The agreement in this case is to run concurrent on both cases. The agreement is to 18 months deferred probation with fine waived on this case, assessed on the second case, 30 hours community service. And the
That's no
state has
contact.
agreed as part of the agreement with the Veterans Program to allow for expunction in this case, provided he completes the probation. And
Let me see, hold on, no contact with.
Sarah, here.
Sarah Malcolm.
And it's Sarah, Phelps, Judge. There's.
Oh,
been a
I was
change.
just looking at how it was stated in the information. It says Sarah Marabella.
Okay.
Oh, what?
That's what it says in the information.
Oh, what should I change it on
No, Your Honor, that she's now changed her name because there's been a divorce, and so she's back to her main name. And so the name that I'd given the court coordinator to put in the judgment was Sarah Phelps.
I think we gotta go by the
Track the
information. You've got to track the information.
Okay.
Yeah,
Okay.
okay, hold on a minute. Let's see, this is state we reached to. Yeah, I don't do the expunctions. That's in Judge, what's the name? Court.
Yeah, it's in Judge West Court. We just, the statute requires that we put it on the record that the state is agreeing to it at the time of the plea, and that's why I put it in the plea agreement.
I think he's well, that's between her, because I think, I don't know if he's eligible for an expulsion.
There is a little
On a
known,
deferred,
there's a rare known provision under the expunction statute that allows any case to be expunged as long as the district
Okay.
attorney's office agrees to it. And since my client is going to be in the Veterans Court Program, Judge, he's an honorably discharged veteran. And since he's going to be in the Veterans Court Program, the DA's office was very gracious in allowing that very rare exception because he's going to complete that program.
okay. Get, let's see, there's no fine. What's the court cost?
Which one is it?
This is this is, 2290.
Okay, it's 270.
277. Let's see, now. This is probation. Now. Let's see, 18, I think that's, 15. There's no fine. Okay. 277 plus 490 plus 270 plus 15, 1652, 1652 divided by 7. Okay, Mr. Marabella,
Yes, sir.
the state is offering that you serve 18 months deferred adjudicated probation during the 18-month probationary period. The fine will be waived. You'll be required to pay court costs of $277. You'll be required to pay probation fee of $6,000 a month, your announcement fee of $15 a month, reimbursement fee of $15. Your total monthly installments in this case is $97 a month. Will you be able to pay the $97 each month? You'll also be required to perform 30 hours of community service. Cannot have any contact with the complaining witness, in this case is Sarah Marabella. And the state is agreeing to recommend expunction. That's what it says here, pursuant to Article, is that 55?
01B2,
B2 of the Texas Code of Criminal Procedure.
Learning all kinds of new things today, Judge.
Now, Mr. Marabella,
Yes, sir.
do you understand the state's offer?
I do, yes.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Mr. Marabella, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Marabella, we'll go to your next case. That's, next case is cause number 23CCCR 0522. And in this case, Mr. Marabella, I have before me on my computer a document that is titled information. And in this information, it alleges that you, Robert Douglas Marabella, on or about March 20th of 2023, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Marabella, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Marabella, how do you plead? Guilty, not guilty, no contest?
Guilty, yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yes.
Now, Mr. Marabella, I also have before me a document that is titled Misdemeanor Plea Minus was labeled as State's Exhibit number 1 on my tablet. And in this document, which is State's Exhibit number 1, there's one box that's checked on the first page. Do you recognize this document?
Yes, sir.
Okay, that's March 20th of 2022. Now, you was pleading guilty to this offense of DWI, which occurred on March 20 to 2023. Is that correct?
Yes.
And on State's Exhibit number 1, do you recognize this document? On page 2 of the same document, there's a set of initials on the line next to the box that said guilty. Or these are your initials.
They are, yes, sir.
And on page 3 of this document, there's a signature above the line that's titled defendant. And is that your signature?
It is.
And on the next document, it's titled trial court certification of defendant's right of appeal. You recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargain case. You have no right to appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have another document that's titled discovery certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
It is.
Now, Mr. Marabella, before you signed in these documents, did your attorney go over these documents?
It is, yes, sir.
And did you understand everything that he went over?
I do, yes, sir.
And is everything in these documents true and correct
It is.
to the best of your knowledge? State.
Stand for 6-1.
Any objections?
No, Your Honor.
No objection. State's Exhibit number 1 will be admitted. And again, Mr. Crenshaw, you were advising counsel, Mr. Marabella, in this case. Is there any evidence that he's currently been incomplicated in this case?
No, Your Honor.
And Mr. Marabella, your attorney, Mr. Crenshaw, is advising counsel you. Are you satisfied with his representation?
Absolutely.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Marabella, I will accept your plea of guilty. I will find that you are mentally competent trial. I will also find that you're playing waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what's the agreement in this case?
As with the previous case, the agreement in this case is to 18 months deferred probation. This is to run concurrent. There's a $500 fine on this case, 30 hours community service, the installation maintained with an interlock device for a period of a year, DWI standard conditions, and the same agreement regarding participation with the veterans program as in the previous case.
What is this court cost? $392. Okay, so this. Actually, we'll have to pay that. Oh, this $8. Okay, now, Mr. Marabella, the state is offering that you serve 18 months deferred adjudicated probation. During the 18-month probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You'll also be required to pay a DWI conviction fine of $100. You'll be required to pay $15 reimbursement fee. You'll also be required to pay Jefferson County DWI education initial evaluation fee of $125 on the day of the should the evaluation be needed, you will be required to pay an additional $50. Now, you will not be required to pay the probation fee of $60 in this case, and you will not be required to pay your analysis fee of $50 in this case, because this case is running concurrent with your previous case.
Yes, sir.
So, your total monthly installments in this case is $48 a month.
Okay,
Will you be able to pay the $48 each month?
yes.
Okay.
So
You also be,
Sorry, go ahead.
okay, you also be required to perform 30 hours of community service, install an interlock device on any vehicle that you own or operate for 12 months of your probationary period. You'll attend and complete the DW education class. You have an alcohol assessment. You'll also be required to participate in the Veterans Court program. And agree to recommend, and the state is also agreeing an expunction in this case as well. And that's pursuant to Article 55.01B2. Now, Mr. Marabella, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yeah.
And do you accept the state's offer?
Yes, sir.
Mr. Marabella, I'll follow the plea bargain agreements that you have entered into with the state. Mr. Marabella, this will conclude your case. You'll gonna stand in front of the court coordinator. Now, let me tell you this here. Your paperwork is gonna reflect that you're required to pay a probation fee and your analysis fee in both cases, but the probation officer is gonna make those adjustments. Okay? All right, just stand in front of the court coordinator, follow the bailiff. Just have a seat right there. And when the bailiffs come back in, you're gonna follow the directions of the bailiff. And once you finish following her directions, you're free to go on your blessed day. And Mr. Crenshaw, this is your last case?
Okay.
No, Your Honor, I have one more.
Oh, yes.
Mr. Ibarra.
I believe he's on the pretrial conference as well.
He's on. And where is it? Oh, there it is. Mr. Ibarra. Your full name is Julian Demetrio Ibarra? Mr. Ibarra, would you please raise your right hand? Mr. Ibarra, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Ibarra, you may put your hand down. How are you doing, Mr. Ibarra?
Pretty good.
I'm doing fine. Thanks for asking. Mr. Ibarra, you're represented in your case by your attorney, Attorney Curry Crenshaw. Attorney Crenshaw, do you waive a record in Mr. Ibarra's case?
We do, Your Honor.
And Mr. Ibarra, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Julian Demetrio Ibarra, on or about March 6th of 2021, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with alcohol concentration level 0.15 more. State, are you abandoning the enhanced paragraph?
We are, Your Honor.
The state is abandoning the enhancement paragraph. What that means, Mr. Ibarra, it means instead of being charged with a Class A misdemeanor, you'll be charged with a lesser included Class B misdemeanor offense of DWI. Now, to the Class B, misdemeanor offense, driving while intoxicated, which allegedly occurred on or about March 6th of 2021 while you were in Jefferson County, Texas, operating a motor vehicle in a public place. How do you plead? Guilty, not guilty, or no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Bauer, I also have before me a document that is titled misdemeanor plea admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials on the line next to boxes check guilty. You place your initials on this document.
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that
Yes, sir.
statement? Second box that's checked states that you are waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled discovery certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes, sir.
defendant? Mr. Bauer, before you signed and initial these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And Mr. Bauer, are you a citizen of the United States?
Yes, sir.
State of your state's one.
Any
No
objections? No objections. State's exhibit number 1 will be admitted. And Mr. Crenshaw, you advised and counsel Mr. Bauer. In this case, is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Bauer, your attorney, Mr. Crenshaw, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir.
Mr. Bauer, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendants to waive, the state's offering 1 year deferred probation, $500 fine, 40 hours community service. DWI first standard conditions of probation, and the interlock will be agreeable to 6 months. Discovery, Your Honor.
You go on the back of that other page. What's the full cost in this case?
319.
Okay, Mr. Bauer, the state is offering that you serve 12 months deferred adjudicated probation during the 12-month probationary period. You'll be required to pay a fine of $500 for the court cost of $192. You'll be required to pay $100 DWI conviction fine. You will be required to pay a probation fee of $6 a month, your announcement fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you were required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $173 a month. Will you be able to pay the $173 each month?
Yes, sir.
You'll also be required to perform 40 hours of community service, install an interlock device on any vehicle that you own or operate for 6 months of this probationary period. You will also be required to attend and complete a DWI education class, have an alcohol assessment, and adhere to the other standard terms and condition of this probation. Mr. Ibarra, do you understand the state's offer? Yes, sir. Do you think the state's offering your case is fair and just? Yes, sir. And do you accept the state's offer? Yes, sir. Mr. Ibarra, I'll follow people are in agreement that you have entered into with the state. Mr. Ibarra, you're gonna stand in front of our court coordinator. Follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go and you have a blessed day. And Mr. Crenshaw, this is your last case.
It is,
You're
Your
free to
Honor.
go as well and you have a blessed day.
Thank you.
Okay, and happy holidays to you. Okay, let's see. Okay, this is cause number 23 CCCR 2116. Case is style the state of Texas versus Gregory Allen Warner. Mr. Warner, is that your full name?
Yes.
Mr. Warner, would you please raise your right hand? Mr. Warner, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Warner, you may put your hand down. How are you doing, Mr. Warner? That's good, Mr. Warner. You're represented in your case by your attorney, Peter Dahl. And Mr. Dahl, do you waive a record in Mr. Warner's case?
Yes, sir.
Mr. Warner, I have before me on my computer a document that is titled information sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Gregory Allen Warner, on or about June 6th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated. Second, this information further alleged that prior to the commission of this offense, that on June 29th of 2022, in cause number 22 CCCR 26. Hold on a minute. Like a number is missing. Yeah,
You're looking at the information, Your Honor.
yeah, it says 22 CCCR. Oh, that's the Chambers County case. Okay. 22 CCCR 262 in County Court at Law of Chambers County, Texas, that he was convicted of the offense of operating the motor vehicle while intoxicated. Is that true? And to the offense of driving while intoxicated, second, Class A, how do you plead? Guilty, not guilty, or no contest? No contest? Now you pleaded no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Right.
Mr. Warner, I also have before me a document that is titled Misdemeanor Plea Admonishment. Is also labeled as State's Exhibit number 1. Do you recognize this document? On page 2 of this same document, there are a set of initials on a line next to a box that's checked NOLA contingent. Do you recognize, did you place your initials on this document?
Yeah.
And on page 3 of the same document is there's a signature above the line that's titled defendant, is this your signature? And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. You understand that statement? Second box is checked, states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled discovery certification. You recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Warner, before you signed and initialed all of these documents that I just showed you, did your attorney, Mr. Dahl, go over these documents with you? And did you read and understand everything that he went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Mhm.
Mr. Warner, are you a citizen of the United States?
State Upper States 1.
Any objections?
No objection.
No objection. States exhibit number 1 will be admitted. And Mr. Doyle, you've advised and counseled Mr. Warner, is there any evidence that he is currently mentally incompetent to stand trial?
None, Judge.
And Mr. Warner, your attorney, Mr. Doyle, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
You did.
Okay, now, Mr. Warner, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 180 days probated over 15 months, $500 fine, 80 hours community service, DWI second standard conditions of probation are to apply, and the defendant must report to the Jefferson County Jail on Saturday, December 21st by 6 p.m.
Sir, 72 hours.
Yes, sir.
What's the court clause? 392
6 p.m.
and,
That's 7 in the morning.
okay, 3-6.
7 in the morning.
And he was appointed.
Okay, what was? 250. And, let's see, that's 7. Oops, oh man, it's 900.
Work. Only work.
Yeah.
What is this date? This date is backwards, huh? Is that
That's my
said, that says
dyslexia
December
kicking in,
12th?
Judge.
Huh?
That's my dyslexia kicking in.
Oh.
It should be 21.
Oh, December 21st, okay.
There you go, Judge.
Okay,
Thank you.
now, Mr. Warner, the state is offering that you serve 180 days in the Jefferson County Jail. This 180 days will be probated for a period of 15 months. During the 15-month probationary period, you'll be required to pay a fine of $500. Plus court costs of $392. You will be required to pay DWI conviction fine of $100. You'll be required to pay a probation fee of $6 a month. Your analysis will be $15 a month. Reimbursement fee of $15. You'll also be required to reimburse Jefferson County Court appointed attorney's fees of $250. Your total monthly install, and you'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation is $170 a month. Will you be able to pay the $170 each month?
Yes.
You'll also be required to perform 80 hours of community service. You'll be required to install an interlock device on any vehicle that you own or operate. You're required to attend and complete a DWI intervention class, have an alcohol assessment. You will serve 72 hours in the Jefferson County Jail, starting at 6 p.m. It could be on or before 6 p.m. on December 21st of 2024. Do you understand that? Now, Mr. Warner, do you understand the state's offer? Do you think the state's offer in your case is fair and just? Do you accept the state's offer? Mr. Warner, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Warner, this will conclude your case. You're going to stand next to the bailiff, follow her direction. Once you finish following her directions, you'll be free to go and you have a blessed day. All right. And Mr. Dole, I thank you. Linda Wyckoff.
That was gonna be dismissed by the state.
Oh, that was dismissed. Okay. Yeah, I think I've already signed the dismissal too.
Good.
Judge. You called it.
And so that's it for you, Mr. Doyle?
Yes, sir.
You're free to go and you have a blessed day.
Thank you, Judge.
Okay.
Justice J.
Hmm?
Justice Attorney, Justice J.
Yeah, I have Hector Dominguez. Who is that?
I believe they appeared, Judge.
I had him checked off as being here. Hector Luis Torres Dominguez. Is that him? Oh, I don't know. Does he speak? He might speak. Okay, let me go to the next. Joel Espinoza. Oh, that's him. Oh, just okay. Just hold on, Mr. Espinoza. And he has 2 cases.
Do you want him to approach, Judge? He's
Well,
asking.
come on up. Mr. Espinoza, you're represented by Justice Ajay?
Yes,
Okay, have you talked to your attorney today?
it's in the program.
He's
Can
in the
Can
hospital?
I speak for what, Your Honor? I think this might be a conversation best had in the back between you and I. I don't know if you want me to approach it right now.
Okay, just have a seat. You can just have a seat. We'll call you back up. You got some information on something?
Is it what we spoke about as well?
The court's bailiff called the name of Hector Dominguez at the courthouse door. Hector Dominguez appeared. However, when his case was called in court, he has not answered. The time now is 12:58 PM on today's date of December 16, 2024. Miss Bailiff, would you please call the name of Hector Dominguez at the courthouse door?
If not, it's just gonna happen.
No response, Your Honor.
Hector Dominguez name was just called at the courthouse door. Hector Dominguez did not answer. Reasonable time has passed to give Mr. Dominguez an opportunity to reappear. It's not appeared. State, do you have a motion?
Statements on forfeiture.
That motion will be granted. Hector Dominguez bond will be forfeited and warrant should be issued for his arrest and cause number M33020. And Mr. Justice Botchway Ajay was scheduled to be in court with his clients, Hector Dominguez and Joel Espinoza. He has not made an appearance. The court is going to issue a show cause on on Attorney Ajay. I'm going to set that show cause hearing for
It's gonna be here January, the week of January 13th or Tuesday, January 21st.
Okay, gonna be January 21st of 2025. And the court will be in recess, the trial docket at 1:30. Prosecutors, your excuse.
Thank you.
You're welcome.
No.